The Health Insurance Portability and Accountability Act, or HIPAA, forbids sharing, transmitting, or divulging of information designated as protected health information, or PHI, of individuals. It's designed to offer workers specific protections. HIPAA limits the use of pre-existing condition exclusions, prohibits group health plans from denying coverage or increasing coverage rates based on past or present poor health, guarantees certain small employers and certain individuals who lose job-related coverage the right to purchase health insurance, and guarantees, in most cases, that employers and individuals who purchase health insurance can renew the coverage regardless of health conditions of individuals covered by the policy. To put it simply, HIPAA lowers the chance of losing existing coverage, makes it easier to switch health plans, and helps individuals buy their own coverage if they lose the coverage offered by a present or former employer. Businesses are charged with the responsibility of complying with the provisions set forth in HIPAA, and this program was designed to help you reach this goal. Obviously, we can't cover every detail relating to HIPAA in this short video, but we do hope to help you understand what the HIPAA rulings mean, what your company must do, and the steps that must be taken to bring your organization into compliance. Here's what your organization must do to comply. Each organization must designate a privacy official. The basic responsibilities of the privacy official are tracking all protected health information, or PHI, making sure that legal issues are addressed, coordinating with other employer functions, setting up structures to ensure individual rights, setting up a complaint process and sanctions, developing overall privacy policies and procedures, auditing and monitoring the program, keeping up to date with the latest privacy developments, and developing employee training programs. After employee training in HIPAA matters is completed, everyone in attendance should fill out a form complete with their name, the date of training, and their signature acknowledging that they understood the material presented in the training class. Data security standards must be introduced to safeguard the confidentiality and integrity of PHI. Some ways this may be achieved include: ensure that a private area is established for discussions about benefit plans and related issues. Position computer monitors displaying private information so they cannot be seen by unauthorized individuals. Protect information on assigned computers with passwords or other security devices. Implement policies to maintain the privacy of telephone discussions relating to PHI with individuals, relatives, and service providers. Prohibit leaving voicemail or answering machine messages discussing PHI. Ensure that email is confidential by implementing encryption or other security measures. HIPAA's privacy gives plan participants and beneficiaries the right to inspect and copy their PHI, which must be held in a designated record set. This designated record set should include any documents related to the following health plan operations: enrollment, eligibility, claims adjudication, claims payment, appeals determinations, case or medical management, and disability management. This designated record set should be maintained separately from any employment or other employee records. HIPAA requires entities to provide individuals with a Notice of Information Practices. This notice should describe the uses and disclosures of PHI, the individual's rights, and the covered entity's responsibilities. This notice must be provided to the named insured. This notice and all other documents related to HIPAA must be retained, either in written or electronic form, for at least 6 years. The employer authorization form allows the use and disclosure of PHI both by the covered entity requesting the authorization and a third party. It must be written in specific terms to allow PHI use and disclosure for purposes other than those of treatment, payment, and healthcare operations. The individual rights form must be completed when an employee wishes to have access to their own PHI or protected health information. This form entitles the individual access to only the information contained in their designated record set. The plan's administrators will issue a form outlining the reasons for granting or denying the request. Individuals covered under the plan may also request to correct or amend their records or information contained in their PHI. There is a form to grant or deny this request as well. The Department of Health and Human Services, Medicare program, other federal agencies operating health plans or providing health care, state Medicaid agencies, private health plans, healthcare providers, and healthcare clearinghouses must assure their customers that the integrity, confidentiality, and availability of electronic protected health information they collect, maintain, use, or transmit is protected. The confidentiality of health information is threatened not only by the risk of improper access to stored information, but also by the risk of interception during electronic transmission of the information. One goal of HIPAA is to adopt national standards for safeguards to protect the confidentiality, integrity, and availability of electronic protected health information. Currently, no standard measures exist in the healthcare industry that address all aspects of the security of electronic health information while it is being stored or during the exchange of that information between entities. Section 1173D of the Act provides that covered entities that maintain or transmit health information are required to maintain reasonable and appropriate administrative, physical, and technical safeguards to ensure the integrity and confidentiality of the information and to protect against any reasonably anticipated threats or hazards to the security or integrity of the information and unauthorized use or disclosure of the information. These safeguards must also otherwise ensure compliance with the statute by the officers and employees of the covered entities. A current Notice of Privacy Practices, NPP, must be distributed to all patients, including posting on your website. The NPP must be up to date and include these elements: a statement that certain uses and disclosures of protected health information, PHI, require an authorization from the subject individual, specifically psychotherapy notes, if recorded or maintained by the covered entity, PHI for marketing purposes, and in instances constituting the sale of PHI. A statement that uses and disclosures not addressed within the NPP require a written authorization. An acknowledgement that the individual may revoke any authorization granted for uses and disclosures requiring such authorization, and a notice of the individual's rights following a breach of unsecured PHI, which can be sufficiently accomplished with a statement that the individual has a right to or will receive notification of a breach of the individual's unsecured PHI. There are also limitations on the use of protected health information for marketing and fundraising purposes. The sale of a patient's personal health information without individual authorization is prohibited. Business associates are directly regulated and responsible for complying with HIPAA. As of September 23, 2014, all business associate agreements must reflect the new requirements. The new rule expands the definition of business associates by including subcontractors who create, receive, maintain, or transmit protected health information on behalf of a business associate, health information organizations, e-prescribing gateways, and certain other persons that provide data transmission services for covered entities, and persons that offer personal health records on behalf of a covered entity. Business associates must comply and require its subcontractors to comply with applicable requirements of the HIPAA security rule. To ensure compliance, you should identify all business associates, review existing business associate agreements, and amend to comply with the new rules. Ensure that all business associates execute an updated business associate agreement. Continue to exercise diligence in establishing and monitoring business associate relationships. This is a perfect time to review your HIPAA compliance program. It's not too late to become compliant. In addition to the action items identified above, we recommend the following. Ensure that your organization's privacy officer and security officer are up to date on all the new rules. Conduct a risk assessment to determine the likelihood of a data breach. Review and update HIPAA privacy and security policies, including those related to business associates and notice of privacy practices. Retrain the workforce on updated policies and procedures and establish a schedule for ongoing training. Establish monitoring and internal audits to avoid lapses in the privacy and security of PHI. As we mentioned earlier, we cannot possibly address every aspect of HIPAA compliance in this short video. It's up to each organization to determine the best way to achieve compliance. There are many resources available to help you achieve this goal. HIPAA requirements are here to stay. The sooner your organization is in compliance, the better off your organization will be. Thanks for watching.